Yeah, hello everybody. Today's video is probably a short one, only some remarks about dispute resolution mechanisms in double taxation treaties or similar things, because that fits here just because in the case of the transfer pricing issues, we always have the risk that two states do not come to the same results. So just remember, there is no real market price. So if two states try to determine the market price or criticize the market price which the taxpayer wanted to bring forward, then it's highly plausible that the market prices which they regard as correct deviate from each other. Now, economically, that is more or less a kind of a catastrophe, because then the total of the amounts which are taxed by both states is higher than the total of the amount which you really earned. That might, for example, work this way. Imagine a GmbH has raw material for 10 euro from outsiders and then adds own costs of 100 and sells the half-finished product to a sister company, that's BBV in the Netherlands. This company then also does some own work with costs of 100 again, and the final product is sold again to an outsider for a price of 500. Now imagine the German fiscal authorities think the adequate market price between A and B is 300 euro, whereas the Dutch think that BBV should only pay 200 euro to the German sister company. So there is a deviation of 100 between the two adequate market prices on which the two fiscal authorities base their calculation. This has interesting results. Total profit for the whole group is, when you make the calculation, 290. But Germany assumes that a GmbH made profit of 190. You see the calculation just here. Now, if the Dutch say that the adequate purchase price which BBV should have paid to a GmbH should only have been 200, then we end up with a Dutch profit of 200. And now if we add these two together, we have a total of profits claimed by the both states of 390, although the real amount of profit for the group was only 290. So the disputed amount, the range where the transfer price is not clear, these 100 are taxed by both of the states, so you end up with a double taxation, which was never intended. And well, you only earned the 100 once, you have to tax them twice. And if you go to court, probably each of the two court decisions says we are right, the others are wrong. And so you end up with a final taxation of 100 being taxed twice. And everybody says, not my fault, your problem. Now, when you want to solve this, you face a problem. There is no authority, at least within the inland legal system, which can force both states to agree on the same solution. Every authority can only be brought to its own court, and if the court decisions deviate, then you can't bring them to agree with each other. That's a problem, because especially with the transfer pricing issue, many different notions of what the adequate market price should be are possible, and so it's highly implausible that two courts in different states, after a long debate, really agree or find independently the same market price. So probably the differences can perhaps a bit be reduced by a court decision, but the problem can't be eliminated. So if you really want to get away from that problem, you should install mechanisms which force the two, or at least enable the two fiscal authorities to agree on a common decision, on a common view of the facts. And that could be a kind of a mutual agreement first. But you remember probably when you look to the double taxation treaties that in the OECD model we have an Article 9 which says in its second paragraph that if a state is faced with a correction of the transfer prices made by the other state, and if that state really thinks that correction is correct, then it should follow that correction and correct its own transfer pricing calculation in the same way. This is a rather weak instrument to guarantee a common treatment of the case, because naturally in that situation it will be relatively rare that one state says the market price put down by the taxpayer is wrong, I correct it, and that the other state claps, says hooray, and says I'm going to take over that point of view of my colleague from the other state, because for them a corresponding correction would probably mean a loss of revenue. On the other hand, the states are not really bound to something strange or really restricting by that clause. Nevertheless, it can be found that some states refuse to take over some or a clause like Article 9.2 because they just wanted to avoid being bound by corrections of other states, even in such a case. Naturally, that should be a kind of a minimum standard. If you, as the fiscal authorities responsible, really think that the correction, the market price set by the other state is correct, then you should take it over for your own calculation. But spoiler alert, usually you will not think that. So Article 9 will not solve the problem sufficiently. So you need something else, and here you remember Article 25, mutual agreement procedures. You give under the DTT the two states involved, the authority or the two authorities, the permission to talk directly with each other and to agree on a common point of view concerning that case. The other alternative which you have is not only allowing them a mutual agreement, because that's still voluntary and there they have to agree, but to enforce a common view, which then avoids a double taxation just by creating mechanisms for a binding decision. So you need to create an institution or to give the power to a person to decide the case bindingly for both sides involved. That can be done by arbitration. It can be done by enabling a court to decide with effect for both states, or whatever else you have in mind which could issue a binding solution for both states. In that case, you should distinguish the effects of arbitration and juridical decisions, because arbitration usually means the arbiter can decide arbitrarily. So here you don't need to justify the final decision, only the two parties have to follow it. That also implies that no strict legal reasoning must be brought forward to give reasons that your decision is the one and only. And that also means no juridical tradition will be started. There will be no set of case law by which you are bound in the future. That would be different if you set up a court which can decide for both parties, because the court will usually try to find very good arguments for why they have to decide in this situation in this way, and these arguments will probably be prejudices to further cases in the future. So that's rather more binding. By that traditions could be started which make the existing rules more detailed and more concrete, and probably you want to avoid that. Um, but in both states, the states would have, in both cases, the states would have to take part in a binding mechanism where they have to renounce on something which they claim as their revenue, and that also means that they will require, that requires trust. Um, you need the conviction that you can find people who are able emotionally and so to decide in a neutral way between the interests of the two states involved. Um, and that trust does not always exist. For example, can't imagine really that North Korea and the US could agree on an arbiter which they both regard as equally neutral and trustworthy. Or Iraq and the US could probably, in former times under Saddam Hussein, not agree on a neutral arbiter. You will have many instances of this. So a binding arbitration or even setting up a court as a superior instance, that is probably still a rare solution. So that is the explanation why you find in the double taxation treaty model conventions and in most double taxation treaties only a rule about mutual agreement procedures. There you should keep in mind that the characteristic of a mutual agreement procedure is there is no decision possible without both giving their consent. So if one of the two states does not want to help you or does not agree to the final compromise, then you don't get a solution. The next restriction is that a mutual agreement procedure only is allowed for the application of the existing rules in the double taxation treaty. So if a problem shows up for which the double taxation treaty has no solution, then the fiscal authorities are not allowed to create one on their own. They are only allowed to apply the existing rules in a way which leads really to a solution which the legislator had in mind. So a uniform and non-contradictory solution which avoids double taxation. So they can agree on a common view of the facts and a common application of the existing rules. Nothing more. They could not even create strange new interpretations of the existing rules, because what the laws mean, that's a question which is to be decided by the courts, and the courts are not bound by the interpretation of the authorities. So the influence or the scope which a mutual agreement can cover is relatively restricted. A last warning point: if a state decides for a legal rule which is a treaty override, a mutual agreement can usually, or perhaps at least, not really help, because if the two authorities involved agree on how the rules of the double taxation treaty should be applied or could be applied in a uniform way, and then one law says, well, I don't care about the double taxation treaty rules, I override them clearly. So I do not only bring forward a rather excessive interpretation of the double taxation treaty, but I clearly put it aside, waive it, and break that rules, then a mutual agreement can probably not help you. What you should always know naturally is how such a procedure works. That's standard basic knowledge. So who has to apply for it? How is it organized? How shall the authorities react to your application, and all these things. When it comes to arbitration procedures, ladies and gentlemen, a legislator who wants to accept an arbitration procedure has to think about several questions first. naturally you need to to agree on who is going to make the arbitral decision, but there are other questions combined with that. For example, shall arbitration only start if both states agree on an arbitration, or um, that would be a case of voluntary arbitration, or shall arbitration already be possible if only one state demands arbitration, or if only the taxpayer demands arbitration? That would be compulsory arbitration, and naturally that's a difference. For example, imagine the taxpayer could have the idea we could abuse arbitration. Imagine an adequate transfer price would be something between 200 and 250 euro. And now I just declare 150. And so it's far off what could be correct. But then I rely on that state B now will defend its part of the prey, 350, which I just arbitrarily gave them with many efforts, and that probably when they fight with my fiscal authority, that the result which they can achieve is far better for me still than the correct 250 or so, or 200. So I could try to abuse arbitration in a way that I say, well, I just declare an invented price, a fantasy price. And the idea is, by this, I trigger the arbitration procedure, and I know that the fiscal authorities of the other state really fight in an arbitration negotiation, or that the arbiter doesn't like my state at the moment, or I hope for a better outcome than the right one. And that would be a great idea. Just declare something completely insane and then hope for arbitration. You save a lot of bureaucratic costs, and that is what naturally the fiscal authorities want to prevent. Now with the voluntary arbitration, you have no problem with that, because if you have the impression the taxpayer doesn't deserve arbitration, there was some tax fraudulent behavior or extreme carelessness or something illegitimate in the background, then you just say, I do not agree to arbitration in that case. In case of voluntary arbitration, every state can stop it, and only after you agreed this taxpayer deserves arbitration, then you will be bound by the final arbitration decision later. That would be the difference to mutual agreement, where you have to agree in the end. Here you can only say no in the beginning, when you do not yet know the outcome. But imagine you have a compulsory arbitration. Whenever one party says, okay, I want arbitration, then you are bound to start arbitration. So you will probably want a kind of emergency brake to prevent people from fraudulent behavior, who then think, okay, arbitration probably brings more or better fiscal outcome for me than if I honestly follow the rules. Very often you will find, for this reason, in arbitration clauses some kind of emergency clause which says, if one of the states involved suspects the taxpayer of tax fraud or similar behavior of illegitimate or illegal kind, then that state can refuse to start the arbitration. Here you can still distinguish between two alternatives. You can either say a state can say no, so that one state's refusal is enough. Then you could also have the policy of a state where the fiscal authority abuses the emergency brake rules and says, I now look for everything which is a bit fishy, and always say, this was illegitimate enough, I refuse consent to arbitration. you could probably bring that to a better level of legal certainty if you say, if both states agree that the taxpayer doesn't deserve arbitration, then arbitration doesn't take place. If one state says, yes, it's my honest belief that the taxpayer deserves arbitration, that then arbitration starts already and is compulsory. These would be the little differences which you can bring into play there as legislator. Well, where can you find arbitration rules, ladies and gentlemen? Well, first in double taxation treaties. Relatively rarely, if they are made, they are usually added at the end of Article 25. Then there is a famous arbitration convention of the European Union member states from 1990, started with the 12 member states which existed at that time, was then always extended to new member states with from time to time a very long delay. The idea why that convention was made was one wanted to avoid any jurisdiction from the European Court of Justice. And so it was definitively and deliberately not designed as an EU regulation or EU directive, but as an independent non-EU law treaty between the member states of the EU. The idea was, by this way we can avoid a juridical tradition which established itself and binds our dealing with transfer pricing more and more. The important thing here was the arbitration convention is only valid for transfer pricing issues. All other disputes with double taxation treaty application does not have a right to the binding arbitration here. That problem was then addressed by a kind of an update, because in 2017 the EU brought forward and agreed to a directive on double taxation. This is rather a kind of a misleading title. It's only an abbreviation. And that directive said, now we oblige by EU directive the EU member states to establish a binding arbitration procedure for every dispute which might arise in the concrete application of a double taxation treaty rule. Here again, we have the same problem with which we have with mutual agreements. If there is a treaty override, that does not help. And if there is no existing double taxation treaty between two member states, that also does not help. But it's nevertheless a great achievement for all the cases where double taxation treaties exist and are not overridden, because now under that rule you could even bring a case to arbitration where the residence of a taxpayer is not clear enough. Imagine, in theory, there might be cases where somebody has no clear center of vital interest, no clear habitual abode, two passports, so double citizenship, so that in the end, even the OECD Model Convention gives up and says, if a taxpayer passes unsuccessfully all these tests for residence state, then in the end the two authorities shall sit together and decide on where the taxpayer is resident without having any legal criterion to decide upon that. So in that case, you could probably now even demand an arbitration decision. The Arbitration Convention of the EU was organized in a way that you can apply for arbitration, that then the two fiscal authorities could debate the case for 2 years, try to find a voluntary agreement. If they could, then the case was over. If they could not find a mutual agreement on your case within 2 years, then a neutral commission was dealing with the case for 6 months, presenting a solution. And then the member states, if they didn't like that solution by the committee, could try for another 6 months to find Another solution which also avoids double taxation and pleases them more. If not, then after 3 years, the decision of the Commission became binding and you had your final decision. What was your market price, your transfer price? 3 years, that sounds much, but in reality, that was a great achievement and progress because mutual agreement procedures can, at least rumors say so, can last for a long time, and that could even have been up to 10 or 20 years before, in a complicated case, a mutual agreement is reached. Until then, you don't know to which state you have to finally to pay your taxes. That's rather a high degree of legal uncertainty. Well, the Double Taxation Directive from 2017 is organized in a similar way. Also there, the fiscal authorities have the possibility to voluntarily agree. The idea there is every state has to create binding mechanisms with other states for arbitration. Naturally, where the arbitration convention is still valid, they probably apply this, or they might establish another arbitration procedure, but every state has now to guarantee that if it's a member state of the EU. You know that we also have as an important EU rule the Anti-Tax Avoidance Directive from 2016. There you will find nothing on arbitration rules. That's not really surprising because you also have nothing on transfer pricing there, and you have nothing which is not directed at fighting tax saving models. That is not really a matter for that directive. The multilateral instrument, which overrides or intends to override many double taxation treaties, on the other hand, that felt the need that more and more problems would come up when the supervision and correct application of double taxation treaties is extended. And so they strongly suggested to the signatory states to improve mechanisms for mutual agreement and arbitration. So there you have some rules in Articles 18 to 26 of the multilateral instrument, which might be also worth a look. Yeah. Now, we have now spent several hours up to now on paragraph 1 ASDG and related issues, so on transfer pricing, so on prices which a company or an enterprise agrees upon with related parties. And the total context there was something, well, how can we manipulate the tax base of an enterprise? First alternative was that contracts with other states on transfer pricing here. Now there is another way of contracts with other states, how you can manipulate the tax base, and that will be by taking up credits from other enterprises in the group. But this is an issue for next time. I thank you very much for listening to this small video. Hope that you come back soon and wish you a nice rest of the day. For today, it shall be enough. Thanks for watching. Till next time.